I love you. I love you, tiny kitten. I love you, tiny kitten. Oh, my girl. I love you. Hello, everybody. Hi, Ava. Hi, sweet baby. Hi, tiny kitten. Hi, Ava. Tiny. She just wants to rest her head on Mama. She being so sweet. I don't know what that's going to sound like, but she decided she wanted to rub up against the microphone, too. a little tiny kitten tribute to y'all. Hi, tiny kitten. Who's Mama's sweet girl? Who's Mama's sweet girl? I see you back there, Earl. Oh, shoot. She saw me. Can't look. Look away. Look away. Hi, baby boy. How you doing? Oh, hi, Snitch. Yes. You guys will get your treats. They're coming. Yeah, where at? They're coming right now. I had to give Ava hers. I'm sorry. Would you like to declare anything else before we go? Anything else you'd like to say? No? You got this? You got this, Tiny? Ow! Snitch! You just bit the underside of my arm. Trying to get Mama's attention. What was that? What was that? Little brat? I love you. Extra camera and share. There we go. There we go. Oh. Come on, you two. You be nice. Come on. You be good like Earl always is. Billy, I'm doing treats. Tiny hasn't moved. Tiny's like, I'm just gonna wait here for mine. All right. There, that's enough. Oh, Billy's on the bed. I see that little white paw flailing in the pillow there. Here, Tiny. Come on over here and have yours. I'll move the old treat jar out of the way. Hide the new one because y'all got it last night. I just let you have it. All right. What? You're not moving. You don't want treats? You want mama? Well, this is a change, and I am here for it. Hi, sweet baby. Oh, my good girl. I love you. I love you. I love that you're picking me over treats right now. Like, that is special. Mama's tiny girl. Sweet baby. Sweet, sweet baby. Here, why don't you want, here, can you, no? Okay. I guess today is your day to claim right in front of the keyboard. I'm not gonna stop you. There's Billy. Here's the kitty Billy. All right, guys. Hello, Jerry Matthew Boyd. Hello, Nana Laura. I wasn't ignoring you, sweet girl. Okay, you can come back up. Come on. Come on up. Sweet girl. Mama, baby. I love you too. I love you too, Ava. Good doggy. Come on, baby. Come on, baby. Yeah. Yeah, you're such a good girl. You got eye boogers. I love you anyways. Hello, Anna Banana. Hello, Fuzzy Pug. I turned the AC back on today. We had a few days of nice and cool stuff going on out there, and no, today it was really humid. I wasn't feeling well last night. It was a rough night. And so I turned the AC on bright and early, not the first hot flash. I'm done. I'm done already. So. Hello, Frank. I understand, and I appreciate that you're here. Thank you so much for joining us. Hello, Jean Callum. Hello, Eileen and Carlin. Hello, Charlie. Hello, Dark Zoomy. Light a man a fire and he'll be warm one night. Light a man on fire and he'll be warm for the rest of his life. Thank you. Thank you for that. Oh, I needed that. Oh, hello, Mortimer Duke. Oh, you guys are the best. Hello, Penny. What? It jumped. Yeah. He and Earl had a pre-snack. Ava's Earl leaves crumbs when Earl eats, so Ava's cleaning Earl's crumbs. Snitch is on the floor there, laying on that it had the ball that rolled, and that was to contain it, and now the ball is somewhere probably under the bed. And its battery's probably dead. They really like that, and they keep tearing off the fuzzy band that goes around it. So sometimes I'll find the ball but not the band, and sometimes I'll find the band without the ball. Whatever. They're having fun. Eventually I get them both back together. Yes. You get to see Snitch's butt and Billy's butt. Here comes Billy's butt. There's Billy's butt right there. He's giving you an extended show. Saturday, 3 p.m. tomorrow. Spider-Man movie in Discord, courtesy of Jerry Matthew Boyd. He's so good about all that. Hi, tiny kitten. I have a tiny little shadow tonight. I am not complaining. And then we go right there. Not, oh, he was a great actor. He was in such and such. Oh, wasn't he the guy that played in da-da-da? No. Oh, there's new pictures of him. I love you. He means weren't. I was talking to him earlier, and I told him I wasn't feeling well. I had a rough night. I really did. I had a really very uncomfortable, very unpleasant night. But I'm here. You guys always make me feel better, and I love you guys, and I love spending time with you. And besides that, I found some good stuff to watch. I gotta share it with you guys, and I can't share it unless I'm here. So y'all just have to tolerate me being me. Tonight's main complaint is when I was driving, I had something fly into my eye, and I've been shooting it full of Visine, but it hasn't taken all the discomfort away. I don't know what hit me. Sand or something, I don't know. But there's nothing stuck in there. I've taken plenty of pictures of my eye. Hello, Spider-Man. Now, if it keeps, it's just I turned my fan off, my overhead fan. I turned that off, because when the wind hits it, then I'm like this. I'm like, there's no way I'm streaming like this for the night. And then I thought, well, I'll just wear an eye patch. And no, I will not. I'm sure we could make it work, but I'm not gonna. I'm just gonna tough through it. I did. I missed Jerry. I missed Jerry. I love Jerry. He's he's the my favorite person to pick on. Hi, Billy. Hi, baby boy. You joined us. Hi, silly boy. Look at you. You hate this, don't you? Yeah. Yeah, you're not happy? But this is what you get at the beginning of the stream because I'm busy and you're in my way. So either you're going to be part of the show or you're not going to be in my way. And I love you. I love you, my baby boy. Billy O.T. There once was a cat named Billy O.T. A handsome boy. I really got to write words to that song. I got to make new sea shanty lyrics that include Billy O.T. Instead of being waiting for the Wellerman. Your nose itch? That's the cutest thing. You rubbing your tiny little nose? Your sweet, cute little kitten nose? Yeah. Here, Mama give you a hand. All right. Do you want to clean this side of the desk? Yeah. Tiny's got that side. You can have this side. There's treats over there anyways. April was fractured already. It wasn't a great accomplishment. Don't take too much pride in it. Oh, they would. 100%. Trust me. They have a very, very dark sense of humor. Very dark sense of humor. Yes. Police, firemen, EMTs. Yeah. With the stuff that they see on the daily, the only way they can keep their head about them is having a good sense of humor like that. Oh, they would find that hilarious. Just a wee bit spoiled. A wee bit spoiled. Thanks, Jerry. Me too. Where's our squishy? He's home today. I was talking to him earlier. Where is our squishy? Billy O.T. Okay. Well, we're not going to wait for him. I love him to pieces, but we're not going to wait for him. Hey, the real McCoy. Good to see you, sweetie. Well, he's got a lot of, getting back home to do. So, anyways, we are going to Michigan. We're going to North Dakota. And then Michigan again. Sorry, I was like, who was the last judge? I knew I had a third one in there. And a big old dab. Oh, don't you say that. Okay, if it's not happening to Jerry, then it's not happening at all. He would be the first to complain. I'm so glad to have you here. And I'm assuming your daughter's doing well? Okay, good. It's just a Morty problem. Refresh, Morty. I am going to put the video on and fill my coffee. Don't you? Oh, well. You refresh right now, mister. I just can't be serious. I just can't do it. Joey Bag of Donuts! Hello! Morty's toast, y'all. Morty is toast. Oh, the real McCoy. I'm glad she's okay. And she'll remember it always. Well, that's funny because a moment ago you were pushing up daisies. Yeah, that's more like it. That's more like Morty. You guys, something else. I don't know what sometimes, but something else.
So this is going to be an experiment. Ms. Rawls, usually when we have someone in custody that needs an interpreter, we bring everybody in here into the court. Are you at your office back on Washington?
Yes.
Okay. All right. So we'll see what we can do with language line and trying to get everybody heard from a different, like Zoom and from in person. So we'll just see how it goes. If you can't do it, then you're going to have to come in so that we can get that done.
That's fine, Your Honor.
Okay. All right, this is Magistrate Milmore. Sir, are you Rodney? Oops, that's not what I'm looking at. Rodney Armstrong?
Yes, ma'am.
Okay, and I would prefer that you don't hang out on the wall, that you stand on the tables at the table, sir, so I can see you better. Thank you. All right, and your appearance, please, Ms. Rawls.
Thank you, Your Honor. Assistant Public Defender Linda Rawls, appearing on behalf of Rodney Armstrong for his arraignment.
Thank you. So your middle name is Dale, is that right?
Yeah.
Okay. All right. So I have to be able to see you and not the back of your head, sir. So. Okay. So this is file number 26-02157OM. This is a complaint in the people of the city of Lansing versus Rodney Dale Armstrong. Sir, it is alleged on or about August 5th of 2026 at 428 South Washington Square, city of, is he sitting on the table?
Yeah.
Sir, you gotta be standing up.
I'm sorry, man. I'm sorry. Damn, I'm sorry.
Okay. Okay. At 428 South Washington Square, city of Lansing, Ingham County, Michigan. Sir, the charge alleges that you did knowingly furnish a Lansing police officer with false information, to wit, an incorrect name, at that location in Lansing during the officer's investigation of a violation of state or local law or ordinance. So that's contrary to law, Mr. Armstrong. It is a maximum penalty on the misdemeanor, 90 days in jail and or a $500 fine. So do you understand the charge and the maximum penalty?
At the time, I didn't understand the way it was said. When it was said to me, then I was up under. I had just came
No,
from
no,
a
no,
bunch
no,
of.
no, no. We don't
Yes,
want to
yes,
talk
yes,
about what
yes.
happened.
Yes,
Yeah,
yes,
because you
ma'am.
wanna-
Yes,
You
ma'am.
want to
Yes,
talk
ma'am.
about
Yes, ma'am.
with your attorney.
Yes, ma'am.
Okay,
Yes, ma'am.
all right. So you have rights, Mr. Armstrong. We're gonna go over those. You have the right to plead
Okay.
not guilty, or stand mute. You have the right.
Oh,
Let me just get through this. Do you know your rights? Because I want to make sure.
Somewhat, a little bit, ma'am, a little bit.
Okay, well, let's just go through them because they're really important, and I'm sure Ms. Rawls would agree with me. So just bear with me so we can get through this. All right, you are presumed innocent. Okay, if you're found guilty, it has to be beyond a reasonable doubt. So you have the right.
I get it, ma'am. I get that. Yeah.
Good. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, Mr. Armstrong, the court can order them to appear. You also have the right to a lawyer, and if you can't afford one, we're going to get one for you at that court cost. Do you understand those rights?
Yes, ma'am.
Is there? Good. Okay, and is he applying for an attorney, Ms. Rawls?
Yes, he is, Your Honor.
All right, very good. I think that's a good decision. So we're going to enter a not guilty plea for you, Mr. Armstrong, so you can come back. You'll talk with your attorney about how to handle this and prepare a defense. And that hearing is coming up. That's Monday, October 5th. That's at 9:30 a.m. with Judge Buchanan. So you should have the notice to appear and a yellowish color notice for your instructions. You got it. Perfect. That's exactly what we need to make sure you got. Okay, thank you. Bear with me. I just got one thing that I need to look up here, sir, and then I'll be right back with you. Okay, so I'm looking at you've been in this court a few times, and my goal here is to make sure that you keep coming to court. You do have, let's see.
Yep, one more here.
Okay, so I am going to grant you a PR bond on this. It's not a violent charge, okay? And you know that you've got your next appearance date, October 5th, so you don't want to miss that. You've got your paperwork. So I am going to set a $100 PR bond, Mr. Armstrong. So I'm going to tell you, don't miss any court dates. Don't violate any state or local laws while you're on bond. Don't leave the state without permission, and got to make sure that you follow all these conditions to remain out on bond. Do you understand that, Mr. Armstrong?
Yes, ma'am. Yes, ma'am.
All right. Anything else for the record, Ms. Rawls?
No, Your Honor.
All right, then you're all set, sir. That concludes your arraignment.
Yeah. Yeah.
So this is gonna bring me. And then after that.
You're kidding me. You're kidding me. That was the best part. I'm reading your comments. Is anybody else experiencing the buffering, or is it just Jerry now? I love how he orders everybody around. No, see, it's just you, Jerry. Your turn. First, Morty. Morty sent you a curse, and it's just Jerry. That was the best part. Sorry you missed it, Jerry. Hold on, let's see. I'll go back just 2 seconds. Let's see. 7:32. I don't want Jerry to miss this.
Yeah.
Showing off his third leg. Or covering it.
So this is gonna bring me. After that one.
Okay, I'm gonna take care of a matter here in the courtroom. Officer, I'll be right back with you, okay? Okay.
All right. Barnes County District Court is now in session this August 6, 2026. Time is now 1:10 p.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. We're conducting this hearing by reliable electronic means. It is venued in Barnes County. The Barnes County Courthouse is open and available to the public. The Barnes County Courtroom is open and available to the public, and we are live streaming today's event on the Southeast Judicial District's live stream YouTube channel.
Okay, guys, I gotta take the comments down for this one. And I hate that. But it's just the setup. I can put them back up on the second half of the video. But I wanted you to see this fine young gentleman. And C is about all you're gonna be able to do with him, because you will not understand a single word he says. I assure you. You might get 3 or 4 out of the whole proceeding, but the judge does his best. The judge does his best. Let's get into this one. This one's entertaining. Billy, you are not helping. What are you doing? Oh, my goodness. Okay. Can I please have the button?
Matter is on the court's docket. All involve the same defendant. Court is going to call State of North Dakota versus Dustin Gray Schwab, 02-2026 CR 181, 02-2026 CR 113, 02-2025 CR 58, 02-2024 CR 129, 02-2024 CR 27. Present in court by reliable electronic means is Defendant Schwab. He is appearing from the Barnes County Correctional Center. Present by reliable electronic means for the state, Attorney Tanya Duffy. Before going on the record, the court received an email from Erica Chisholm, who is the public defender automatically appointed to represent indigent defendants appearing at their initial appearances. The law presumes all of those persons appearing at initial appearances in custody are indigent, and so a public defender is automatically appointed. Ms. Chisholm informed the court that she spoke with Mr. Schwab and that Mr. Schwab intended to represent himself. We're going to talk about that in just a minute. But first, Mr. Schwab, were you present in court when your rights were just read?
Yes.
Can you hear and see me okay?
Yeah.
Do you understand your rights, sir?
Yeah.
You have additional rights that apply to differing types of cases. As I mentioned, there are 5 cases in front of the court at this time, 3 of which are initial appearances in new criminal matters. And then there are 2 bench warrant cases. Those are orders to show cause.
Judge,
Orders to show, yes?
Mr.
Ms. Duffy?
Schwab, are you awake?
Yeah. I'm
Because you look like you keep falling asleep.
awake. I'm sorry. I'm very
don't feel very good. My body and stuff is just not.
I'm just making sure you're awake because you keep leaning forward and your eyes keep closing. So you look like you keep falling asleep.
I'm sorry.
You don't have to be sorry. I'm just asking if you're awake.
Peter and
All right, so thank you, Ms. Duffy. All right, so in the orders to show cause case, in some respects, those are treated as probation revocation matters, and in other respects, they might be treated as orders to show cause and a contempt proceeding. With respect to revocation rights, you have the right to be personally present in court, the right to prior written notice of any allegations against you, the right to be represented by an attorney, whether that attorney be privately retained, a public defender, or you can choose to represent yourself. You have the right to reasonable delays to prepare for a hearing. You have the right to an evidentiary hearing where the burden of proof is a preponderance of the evidence. You have the right to a neutral and detached fact finder. You have the right to be informed of the issues that will be addressed in an evidentiary hearing. There are essentially two. The first is whether or not there is at least one willful violation of probation, and two, if so, what the appropriate remedy for that violation is. The rules of evidence do not apply to the extent that these are treated as revocation proceedings. Any ambiguities in the court's judgment or probation conditions are strictly construed against the government and in your favor. You have the right to confront and cross-examine witnesses against you, the right to testify or to remain silent, and the right to present evidence or call witnesses on your behalf and to use the court's subpoena power to force those witnesses to appear. You have the right to be informed of the options for the court. If the court finds that you violated probation, the court has to determine what penalty is appropriate. The court can choose to do nothing if the court finds the violation is a minimal or de minimis one. The court can modify or enlarge probation conditions or extend probation length, or the court can revoke and resentence you up to the maximum sentence originally possible. Before doing so, however, you would have the right to speak to the court and explain and provide any information in mitigation of punishment before.
I apologize, everyone. I did not see him slowly showing skin when I edited this. I didn't look, of course. So, many apologies for that.
I imposed a resentence. Those are your rights to the extent that those hearings might be treated as a probation revocation proceeding. Do you understand those additional rights, sir? Mr. Schwab.
about this.
I didn't hear you, sir.
I'm not understanding a lot of this. I don't know, I'm just not comprehending it, I guess. I don't get what's, I'm in a lot of pain and just not like, not just started comprehending it. I don't know. I'm not on probation, I know that.
Well, sir, you have a couple of hearings from 2024 that you didn't appear. Those were probation actions. One was the failure to obtain an evaluation, which was ordered as a condition of probation. And that was in file ending 27. So that's a 02/2024 CR 27. In that file, sir, you were court ordered as a minimum mandatory penalty to obtain a domestic violence offender treatment program. And the allegation is that you did not complete or file proof of that evaluation. The court scheduled a hearing back in November of 2024 for December 3, 2024. You didn't appear, or at least there was a request to continue that proceeding. It was rescheduled, and then you didn't appear at the rescheduled appearance date on February 4, 2025, and a bench warrant was issued. It was served a few days later. You were given another promise to appear, and
I apologize, guys. Ava has to go potty, so I will be right back. I'm just going to run her out and come right back.
Another court date, and then you didn't appear again. And so a bench warrant was issued for the second time in February of 2025, and it was just served yesterday. So that matter hasn't been resolved yet. So that's still a probation case because of some non-appearances. And then in 02/2024 CR 129, in that case,
Sorry.
well, you don't need to apologize. I'm just explaining to you why you're here. In that case, you entered a criminal, there was a plea agreement.
Wasn't many of this, I live right here in town, it's just that with my medical stuff like that, I don't.
Sir, just hold on. I'm not
Okay.
looking for an explanation right now. I'm just trying to tell you why you're here.
All right.
So in file 129, you entered into a plea agreement. The court issued a judgment. The judgment required you to pay a certain amount of money and serve some jail. And then you didn't appear for the jail right away. And so they issued a bench warrant for your arrest on January 2, 2025. There is also a delinquent notice that was sent because you hadn't paid the money that was ordered. And so another bench warrant was issued concerning the delinquent notice.
I've had a no ice keeper in like 2 years now. I've been trying to get out. Julie Martin for,
Just hold on, okay?
I don't know what you
So
want from me here.
what I want you to do is just hold on and listen until I'm done, okay? And I'm going to give you an opportunity to speak, but just hold on. So you were ordered to appear on July 16, 2025 in that matter to address the non-payment issue. And again, you haven't served the jail that was required to be served in that case. And thereafter, the court issued another bench warrant because you didn't appear. And that bench warrant was just served. So you have two different types of proceedings in that file. And then you have 3 new criminal cases
A cup of water.
in files 02/2026 CR 113. That's a driving under suspension case. In 02/2026 CR 181, that's another driving under suspension case. In 02/2025 CR 58, that is a felony drug paraphernalia, drug possession case where you didn't appear at the initial appearance. So, sir, do you understand why you're here now?
So yeah, I guess, yeah. It's all added up. I guess I don't. Drug charges, I don't know. I thought Casa pled guilty to those already and took care of those because it was their stuff. I guess, as I wasn't running any place, I wasn't going anywhere. I live right here in town. It's not like I was like, it's just to get done. I'm sorry, I'm not
Mr.
trying to.
Schwab, I need you to not make comments about the facts of the case. I'm just asking, do you understand
Oh,
why
I
you're
don't know. I don't know what you want from me. Then I'm sorry. I'm not comprehending this.
okay? Well, if you're not understanding, I need to know why you're slurring your words in a bit that causes me some concern. And Miss Duffy had some concerns that she thought you might be sleeping. Are you under the influence of any substance that's
No,
affecting
I
your
have
ability to understand?
two neurosis.
Okay, you have some medical conditions that are affecting your ability to understand?
Yes, yeah, it's been going on. Yes, I
What
have
kind
severe
of,
neurosis. Lack of oxygen in the system and in the blood. It causes confusion and lack of stuff, memory and stuff like it's and it just will make it go out. It's just.
Miss Duffy, what are your thoughts on whether we can proceed at all right now?
I'm familiar with Mr. Schwab's
I'm
medical
working on
stuff.
getting,
I know that he has substantial medical issues. I think the court still needs to set bond if he's been sitting about a day now, so we could see him tomorrow. In the morning, maybe it would be better. But I think I don't know if he's coming down. I know that he is a drug user, so I'm guessing he's not feeling well because he's coming down. The sleepiness makes me think that it's either probably a substantial amount of pain he's in, or just the medical stuff kind of all coming together. So I don't know if today's a good day for it, but if we move it to tomorrow, the morning would maybe be better.
so.
Mr. Schwab?
Getting appointments and stuff set up to get this stuff taken care of is just taking a while to get things taken care of. But like, I have an animal at home too, and I try not to miss my appointments. Like that is just like I write everything on boards and stuff. I try to get to everything I can. I'm not running for anything. I live right here in town. You know where I live.
All right, so here's what I'm going to do.
do.
I'm concerned that Mr. Schwab is not understanding the proceedings. I'm close to ordering a fitness to proceed examination. I don't know if it's a medical issue or a mental health issue or a drug issue. I am going to set bail today to make sure that bail is postable. And we are going to reschedule the proceedings for tomorrow. And I am going to require Ms. Chisholm to appear because I think it's important that Mr. Schwab's interests be represented, especially if he appears to have significant confusion with respect to his rights or about why we're present in court. So for the time being, bail is going to be set as follows. I'm going to set bail in the amount of $3,000 cash, or in the alternative $5,000 corporate surety.
You can't afford that. I can afford $1,000.
You just stop talking.
I'm sorry.
Additional conditions: defendant shall remain law-abiding. Defendant shall participate in the 24/7 patch program. Defendant shall not leave the state of North Dakota without the advanced express permission of the court. The defendant must maintain at least weekly contact with defense counsel, notify the court of any change of address, employment, phone number, or email within 24 hours of any such change, not possess or use alcohol or controlled substances unless prescribed, not possess a firearm or other dangerous weapon, sign a promise to appear and waiver of extradition, personally appear for all scheduled court hearings and appearances. In this case, I have court dates in September and November, which are the next scheduled court dates in these matters. But in your case, I am going to continue the hearing today until tomorrow, and it will be scheduled for 1 o'clock tomorrow. You must submit DNA sample. Wait.
Tomorrow's Friday.
Tomorrow's Friday. Ms. Strom, is it 11, right?
We can do whatever you want, Judge.
Please put to $1,000
So
bond.
we'll do it at 11 o'clock tomorrow. That'll be your next court date.
Please
And
$1,000 bond.
and then submit DNA sample and fingerprints before release. You shall not drive or operate a motor vehicle without a valid license or privilege to do so. You must have valid liability insurance as required by North Dakota law. And I am going to require you to fill out or complete a public defender application before release as well. Sir, do you understand bail as I've set it for the time being?
Please $1,000. I can afford that. I can pay $1,000 today. You know,
Sir, I've set my bail and we'll revisit bail tomorrow.
all right.
So anything else, Ms. Duffy?
No, Your Honor.
Ms.
Do you want him
Patterson?
transported to the courthouse tomorrow to do this in person instead,
Yes.
maybe? Or, okay. Okay, we'll plan on that.
All right. With that, we're adjourned. Have a good day. Good morning. Barnes County District Court is now in session this August 7, 2026. Time is now 11:18 a.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. We are in the Barnes County's large courtroom. The door is unlocked and open. The building is unlocked and open. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. As such, these are open and public proceedings. I apologize for the delay. The matters on the court's docket were scheduled for 11 o'clock. We had a bit of a delay with getting a participant present in the courtroom, so we waited for him before starting court. Next matter is the court is going to take up State of North Dakota versus Dustin Gray Schwab, files 02-2026 CR 181, 02-2026 CR 113, 02-2025 CR 58, 02-2024 CR 129, 02-2024 CR 27. Present in the courtroom, Attorney Tani Duffy on behalf of the state. Mr. Schwab appears personally in the courtroom. Attorney Erica Chisholm appears by reliable electronic means. Mr. Schwab, were you present in court when your rights were read to you?
Yes, sir.
All right, so those were the rights for the three files in which you are appearing on a new initial appearance. You have a few cases that are scheduled as orders to show cause, which are in some respects treated as probation revocation proceedings, and in some respects treated as contempt proceedings. So I'm going to read you the rights for both probation revocation proceedings and contempt proceedings. To the extent that the hearing will be treated as a probation revocation, you have the right to be personally present in court. You have the right to prior written notice of any allegations against you. You have the right to be represented by an attorney, whether that attorney be privately retained, a public defender, or if you knowingly, voluntarily, and intelligently waive your right to counsel, you can choose to represent yourself. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing where the burden of proof is a preponderance of the evidence and the burden of persuasion rests with the state. You have the right to a neutral and detached fact finder. You have the right to be informed of the issues to be addressed at a probation revocation proceeding. There are two issues. The first is whether or not there is at least one willful violation of probation, and two, if so, what the appropriate remedy for that violation is. The rules of evidence do not apply in a probation revocation proceeding. Any ambiguities in the court's judgment or probation conditions are strictly construed against the government and in your favor. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent. You have the right to be present or to present evidence or call witnesses to testify on your behalf, and to use the court's subpoena power to force those witnesses to appear. You have the right to an explanation of the court's dispositional options if the court finds that you have violated probation. The court basically has three options. Option one, if the court finds that the violation is a minimal or de minimis one, the court can choose to do nothing. Option two, the court can modify or enlarge the probation conditions or extend probation length. Option three, the court can revoke and resentence you up to the maximum sentence the court could have originally imposed back when judgment was entered. Before doing so, you would have the right to speak to the court. We call that the right of allocution. You understand those probation revocation rights, sir? Do you have any questions about those rights? And again, there's also an allegation that you didn't pay certain amounts of money. Those are treated as contempt proceedings. For those proceedings, you have the right to be personally present in court. You have the right to reasonable notice of any allegations against you and in order to show cause. You have the right to bail. You have the right to attorney representation or consultation. Again, you have the right to privately hire a lawyer of your choosing. You have the right to apply for a public defender. You have the right, if you choose to knowingly, voluntarily, and intelligently waive your right to counsel, you can choose to represent yourself. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing and an opportunity to be heard. The standard of proof and the burden of persuasion rests with the movement. The movement must show by clear and convincing evidence that you willfully, intentionally, inexcusably, and unjustifiably committed contemptuous conduct. You bear the burden of proving or establishing any defenses such as justification or impossibility by a preponderance of the evidence. The rules of evidence apply in all cases except summary contempt proceedings. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent, present evidence, call witnesses, and to use the court's subpoena power to force those witnesses to appear. To understand your rights as they apply to contempt proceedings. I didn't hear you.
Yes.
Okay. So in your case, we're going to take them one at a time. We'll take up the oldest cases first. So we're going to address file 02/2024 CR27. In that file, you were originally convicted of domestic violence bodily injury, Class B misdemeanor. That criminal judgment was entered on May 29, 2024, record index 27. On November 18, 2024, there was a request for an order to show cause filed by the prosecutor, record index 29. In that request for an order to show cause, the state alleges as a condition of your probation, you were ordered to complete a domestic violence course by August 27, 2024, and file proof of completion with the court. And as of November 18, 2024, nothing had been filed with the court regarding completion of recommended treatment. The state asked for a hearing requiring you to show cause why you didn't comply with the terms of the judgment and probation. There was a notice of hearing issued. There was a request for continuance, which was granted, and the hearing was rescheduled. You failed to appear at that rescheduled hearing. Looks like a couple of times a bench warrant was issued, and ultimately that bench warrant was outstanding for quite some time. It was served, looks like on the 5th of August. You appeared on this case yesterday, and the court continued the hearing until today because I had concerns about your ability to proceed. Ms. Duffy, are you intending to proceed as a contempt issue or as a revocation issue on this file?
I did not file a petition to revoke his probation. I had just filed a request for contempt, and so I intend to treat it that way.
Mr. Schwab, do you understand why you're here and the proceedings, how they will proceed or how they will procedurally move forward? Okay. So with respect to the allegation that you didn't complete that evaluation and file proof, you can either admit or deny the allegation. If you admit the allegation, there won't be any hearing of any kind. We'll move forward with determining whether or not the court would find you in contempt, and if so, what sanction the court would impose. If you choose to deny the allegation, we'll schedule a hearing where the state will be required to present evidence sufficient to establish that you failed to obtain that evaluation. And then if so, whether or not the court will hold you in contempt and determine the appropriate remedy. To the allegation that you failed to get that evaluation, do you admit or deny? You admit?
I couldn't find no place to go, so you would do it.
Okay, so you admit to the allegation, sir. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to that allegation? Are you admitting to that allegation freely, knowingly, and voluntarily? Any reason why I shouldn't accept your admission, sir?
I couldn't find a place to go, so you would do it, and I couldn't get to Jamestown.
All right. So the court is going to accept your admission. Ms. Duffy, what are your thoughts on disposition?
In this case, Your Honor, I'd ask the court to find a willful violation. There are providers around. Some of this stuff can even be done online. I think that the defendant is in willful violation of the court's order for not doing that eval and the recommended treatment that would have presumably come from that eval. I'd ask the court to make that contempt finding and sentence the defendant to 10 days in jail. He does have 3 days credit for his original sentence. I'm not asking for those to be included, but he does have 1 day credit from when his warrant was served to bringing it to today. So 10 days is my request, credit for 1, and then that's it.
Ms. Chisholm, your thoughts?
Your Honor, I'll leave it to the court's discretion to determine the appropriate sentence. However, I would note that it appears that Mr. Schwab's physical health is in poor condition, so I'd ask the court to take that into consideration.
Mr. Schwab, is there anything that you want to tell me before I make my decision on this file?
No, sorry, my health is in pretty serious condition right now.
I'm having a hard time hearing you, sir. I
I'm
need you to
sorry,
speak up.
my health is pretty bad. it sucks right now. I'm sorry. I wasn't doing very good right now. I'm trying to do everything I can to get it better. It's taking time.
So it's taken time. Is that what you're saying?
To get everything. You gotta go see the doctors and everything, and then medical got. I don't know what happened with that, but wasn't going through again. I don't know. I tried to go back and refile again, but I'm still waiting on that to get done so I can get back in. Get, doctor's appointments and stuff take care of, I guess.
Anything else, sir?
No, God! No, God, please, no! 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 No!
No, I had to go to the ER last night because too much fluid around my heart and stuff. So it's just that too.
All right. So in this file, the court finds that the judgment clearly and unequivocally ordered the defendant to obtain a domestic violence offender treatment evaluation not later than August 27, 2024, and to complete recommended treatment no later than May 24, 2025. The court finds that that judgment is valid and enforceable. Court finds that it has subject matter jurisdiction as a court of record affected by the conduct in this case. The court has personal jurisdiction over the defendant and that Barnes County is the appropriate venue. The court finds an adequate notice and service of the order to show cause. Mr. Schwab admitted voluntarily, knowingly, and freely and intelligently that he violated the court's judgment and failed to obtain that evaluation and finish the treatment. Stop talking. The court considers remedial sanctions. Again, this is a minimum mandatory required sanction for the offense that the defendant pled guilty to. The court's goal here is remedial in nature, to require the defendant to obtain that evaluation, because again, it is a minimum mandatory penalty. And so the court is utilizing the remedial contempt sanction procedure. The court finds that the excuse, I couldn't find someone to do it in Valley City or Jamestown, to be insufficient to establish a defense. The court finds that that conduct in not getting the evaluation is intentional, willful, inexcusable, and unjustified by clear and convincing evidence. Again, the court finds that Mr. Schwab's explanation is insufficient to establish by a preponderance of the evidence impossibility as a potential defense. The court believes that Mr. Schwab has the present ability to purge the contempt, and so I am going to stay the contempt order and allow him to purge his contempt by completing that evaluation and filing proof that he's completed it and completed the treatment as required. Court finds that the conduct in failing to get the evaluation constitutes contempt of court. The court's conclusions are as follows. The court has subject matter personal jurisdiction in Barnes County is the appropriate venue. The court finds and concludes that Mr. Schwab's actions in non-compliance with the judgment concerning the domestic violence offender treatment course is contempt of court. The court finds the appropriate remedial sanction to be 10 days imprisonment in the Barnes County Correctional Center.
To be fair, for the DV victim, can you imagine this man going into temper tantrum mode? Because you know that's exactly how it would be. He would be having a screaming, stinking, stomping, childish fit. And I could not imagine being an officer trying to restrain him, because the moment this man starts lashing out, he's gonna be sweaty. You're gonna just grab on and slide off. Those poor officers, they gloved up. They double gloved. I bet the DV victim, my guess would be it was his mother, who he probably still lives with. Might be wrong, maybe I'm jaded, but you're being nice. Not lying. I'm guessing this guy's pushing 450. That you weren't here for the first half. That 5X shirt that he's wearing, he was showing out the bottom of it.
The court is going to stay that 10 days and give him credit for 1 day on the contempt issue in this case. I'm going to stay the remaining 9 days for a period of 60 days. I'm going to give the defendant 60 days to complete the domestic violence offender treatment evaluation and enroll in the recommended treatment, if any, and file proof of completion of the evaluation with the court within that 60 days. If the defendant is able to do that, he will not need to report to jail. But if he is unable to do so, a warrant of commitment will issue requiring the defendant to report to jail to serve the remaining 9 days. That is the court's order. Anything else on this file, Ms. Duffy? Ms. Chisholm?
No, Your Honor, thank you.
Thank you. Mr. Schwab, do you understand the court's order?
Yes, Your Honor.
Do you have any questions about the court's order? All right. That matter is adjourned. Next matter the court's going to take up, State of North Dakota versus Dustin Gray Schwab, 02-2024 CR 129. In this file, judgment was entered on October 23, 2024, record index 13, driving under suspension, fourth or subsequent offense in 5 years, Class A misdemeanor. Mr. Schwab was ordered to pay $325 at a rate of $50 per month starting November 15, 2024. He was also ordered to serve 10 days in jail not later than January 1, 2025. On December 16, 2024, the court issued a delinquent notice, record index 14, indicating that the defendant had not paid as required. On December 30, 2024, record index 16, the court received an affidavit from Jeremy Wolf, the jail administrator, indicating that the defendant had not reported to serve his 10 days of jail before January 1, 2025. The court issued a warrant of arrest on January 2, 2025 concerning the jail. Delinquent notices were again sent concerning the non-payment of the $325. There was a delinquent notice sent on 6/17/2025, record index 21, which included a hearing date explaining to the defendant that he was required to either pay or appear not later than July 16, 2025.
Yes, Jerry. More charges. Remember, we were dealing with the oldest charges first. Judge is going chronologically now. Keep up, Jerry. Keep up.
At 11 a.m., defendant didn't appear on July 16, 2025 and has not paid. Bench warrant was issued. So again, there were 2 warrants in this case. One related to non-appearance for the jail sentence and the other for non-payment of fees. Bench warrant and warrants were served on 8/5/2026 as evidenced by record 23 and record 24. You appeared on this matter as well yesterday, and the court set bail. Ms. Duffy, are we proceeding under the contempt proceedings or are we proceeding as probation revocation?
Not really either. I would just ask the court to reduce his $325 to a civil judgment, and he's got his 10 days to serve. He's put in 1 day. So I would just let those run along, basically.
Ms. Chisholm, your thoughts?
Again, I would defer to the court's discretion regarding the jail, but it sounds as though bail has already been addressed.
In this file, the court is going to reduce to civil judgment the $325, assuming you have no objection to that, Mr. Schwab.
Oh, yeah.
$325 court fees reduced immediately to civil judgment. In terms of the jail, there's already an order of commitment requiring Mr. Schwab to serve 10 days in jail. Mr. Schwab has been taken into custody on that warrant. We're going to take no further action at this time. Mr. Schwab, you'll be given credit from the time that you were brought into custody, but you must serve the 10 days as required. That resolves this matter. The next matter the court's going to take up, 02-2025 CR 58. Mr. Schwab, just as a reminder, you were read your rights at the beginning of court proceedings, correct?
Yes, sir.
All right. So this is a new case. Have you received a copy of the charging document in this case?
Yes.
In this case, sir, I'm going to share my screen so you won't see my head up there anymore. Instead, you'll see a copy of the charging document. You'll still see the courtroom. That's as big as I can make it. Can you read that from where you're at?
Yeah.
Is your name spelled correctly on the upper right hand or the upper left hand corner of that document?
Yep.
Okay. Madam Clerk is giving you a bottle of water. All right. Sir, you have the right to have this document read to you in its entirety, or I can summarize it for you.
Summarize.
The state alleges that on or about February 14, 2025 in Barnes County, North Dakota, you committed the offense, 2 criminal offenses. The first being unlawful possession of drug paraphernalia, namely paraphernalia used to ingest methamphetamine, and that you have a prior conviction in file 02-2022 CR 411, making this a Class C felony. And because both counts are Class C felonies, we'll talk about the penalties together in just a moment. The state alleges on or about that same date, you also unlawfully possessed methamphetamine, and it was your second or subsequent offense. They have a prior conviction in file 2012 CR 504. Again, both counts 1 and 2 are Class C felonies. The maximum penalty for a Class C felony is 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any applicable minimum mandatory penalties except a requirement that you submit fingerprints and DNA for inclusion in law enforcement's databases. Court fees for a Class C felony total $525. If your conduct resulted in a loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, a conviction of either offense can result in significant adverse immigration consequences, and it might result in significant collateral consequences. Do you understand the nature of the charges and penalties as I've read them, sir?
Yes.
Do you have any questions about the charging document or about why you're here? Because these are felony level cases, I'm not going to take a plea of any kind. I'm going to stop my screen share here. I'm not going to take a plea of any kind in those cases. I will schedule your next court date in those cases, or in that case. Your next court date, sir, is September 10, 2026 at 1 p.m. Central Time. That court hearing is called a preliminary hearing. And depending on the outcome of the preliminary hearing, we might have an arraignment. And at an arraignment, I would ask you for pleas of either guilty or not guilty, but I'm not going to take your pleas today. That may or may not happen on September 10 after a preliminary hearing. To understand when you next need to be in court, sir. All right. And we'll address bail when we get to those other two files together, because I intend to consolidate your bail for all of the files. All right. So the next case we're going to take up, 02-2026 CR 113. Have you received a copy of this charging document, sir? I'm going to share my screen so you'll see it. You see that document, sir? Is your name spelled correctly in the upper left-hand corner?
Yep.
Can I summarize this document? The state alleges on or about May 14, 2026 in Barnes County that you committed the offense of driving under suspension and that you were driving on an area to which the public has the right of access for vehicular use and your license is suspended or revoked as charged. That is a Class B misdemeanor. Class B misdemeanors carry with it a maximum possible penalty of 30 days in jail, a fine of $1,500 or both. The state has not alleged any applicable minimum mandatory penalties other than a requirement that you submit to fingerprints. Court fees for a B misdemeanor total $250. Again, if your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, a conviction can result in significant adverse immigration consequences, and it might result in significant collateral consequences. The law requires me to explain to you, sir, that if you are able to restore your driving privileges within 60 days of the driving offense conduct, that is within 60 days of May 14, 2026, that you can move the court to dismiss the charge. Sometimes the prosecutor will be willing to move to amend or dismiss if you're able to restore your privileges even outside of that window, but I can't force the state to do so. To understand the nature of the charge and penalties as I've read it, to understand the opportunity to restore your privileges and have the case dismissed. Because this case is a misdemeanor, I am going to take a plea of either guilty or not guilty. If you plead not guilty, we'll simply schedule later proceedings and set bail. If you plead guilty, there won't be any trial of any kind. You'd be waiving the rights that were read to you before, and this matter would be resolved. For the charge driving under suspension, how do you plead? Not guilty plea will be entered, and we'll address bail when we talk about all of the cases. Next matter the court's going to take up, 02-2026 CR 181. Stop my screen share for a second and switch it to the charging document in that case. And you see this document. This one might be a little bit harder to read because it's a uniform complaint and summons. That's as big as I can make it. All right. Is your name spelled correctly right here on the third line? Sir, is it okay if I summarize this document, or would you prefer I read it? The state alleges that on or about August 5, 2026, in Barnes County, North Dakota, that you were driving under suspension. And Ms. Duffy, it's unclear whether you're alleging in this case if this is a alcohol-related or a child support-related suspension. All right. So as charged, sir, they're alleging that you were driving under suspension. It's charged as a B misdemeanor, maximum penalty 30 days in jail, a fine of up to $1,500 or both is the maximum penalty. There are no applicable minimum mandatory penalties other than a requirement that you submit to fingerprints. Court fees total $250. Again, the court has the ability to enter restitution if your conduct caused any loss or financial harm to another person. If you're not a United States citizen, a conviction can result in significant adverse immigration consequences and might also result in additional collateral consequences, just like the last case. If you were driving, or if you're able to restore your privileges within 60 days of August 5, 2026, you can move the court to dismiss the charge. Sometimes the prosecutor will move to amend or dismiss even outside of that window, but I can't force the prosecutor to do so. Do you understand the nature of the charge and penalties? Do you understand the ability to restore your privileges and move to have the case dismissed within 60 days. All right. So again, I'm going to ask you for your plea of either guilty or not guilty. The not guilty plea will be entered. Now we'll talk about bail as it applies to file 02-2026 CR 181, 02-2026 CR 113, and 02-2025 CR 58. The other two cases have been resolved. Bail was already set in all 5 cases yesterday at 3,000 cash, or in the alternative 5,000 corporate surety plus non-monetary conditions. I'll hear first from Ms. Duffy, then I'll hear from Ms. Chisholm, and then I'll give you an opportunity to speak on bail. Ms. Duffy.
The defendant has fairly substantial criminal history that began back in 2004 with criminal mischief. There was some forgery, driving issues mostly along the way, simple assault, actual physical control, possession of drugs, and paraphernalia began in the 2012 area. He had simple assault on peace officers as well, a child neglect and abuse in 2013, some more DUIs in 2013, quite a bit of driving stuff, possession of meth and drug paraphernalia, as well as carrying a concealed weapon in 2020, drug paraphernalia in 2021, disobedience in 21, felony drug paraphernalia in 2022, domestic violence, that one we talked about earlier today, in 24, and then some more driving issues. Then the last 3 brings us to the 3 that you just went through with the drugs, meth, and then the driving issues again. The defendant I know that he lives locally. I know he lives over in the Viking Trailer Court. I know that he lives locally. However, he just doesn't come to court. So I think that does warrant a cash bond in this case. I would ask the court to, the bond that was set yesterday, I think is appropriate, the 3,000 cash or 5,000 surety with the drug patch. I think that is still appropriate, and I'd ask the court to keep it the same.
Thank you. Ms. Chisholm, your thoughts?
Thank you, Your Honor. We'd ask the court to take into consideration allowing the defendant to post 10% of that cash bond. As Ms. Duffy notes, he does live locally and he does have a number of other cases pending. He does also have a significant health issue or issues that he needs to attend to. And I do think, given the circumstances going forward, that he will be appearing in court in light of those. Thank you.
Mr. Schwab, again, you have the right to remain silent. If you choose to remain silent, that silence won't be used against you. If you choose to give a statement, sir, understand that the statement will be recorded and anything you say can and will be used against you. So I would advise you to limit your comments to that of what you think bail should be and why, not about any of the underlying facts of the offenses. You understand the court's warning, sir? Is there anything you want to tell me before I set bail?
Just my health stuff, and I have animals at home. I do live right here in town. That's about it.
What am I to do, Mr. Schwab, when you have a significant history of just not showing up in court?
I need to be able to get my mail and stuff too. I don't know. I will show up. I mean,
So what's different now than the cases that you didn't appear before?
if I get someone to help me remembering it, like, my family member or something like that, or just to help me remember the dates and stuff like that.
Why impose on your family members like that? Just get a damn calendar. Write your stuff down. Be an adult. Stop acting like a giant, whiny, petulant child. You don't need your family members to keep track of your appointments for you. You are a grown man. Stop abusing substances and grow up.
Times. That's what it comes back down to, is remembering.
All right. Bail is going to be amended from yesterday, but slightly. I'm going to set bail at $2,000 cash and an alternative $5,000 corporate surety. All the other remaining conditions remain appropriate. Paragraph 10 with the court dates changed in light of the no longer needing the order to show cause dates. And so your next court date is September 10, 2026. That's a preliminary hearing in file 02-2025 CR58. The other two dispositional conferences are scheduled for November 3rd, 2026 at 1 p.m. All of the other conditions remain appropriate and are still imposed. I reduced your bail, sir, a bit in light of the fact that you are local and in light of the fact that we're now talking about 3 cases instead of 5 cases. And so I reduced your cash bail amount by $1,000. But in light of your repeated non-appearances and the lengthy period of time that the bench warrants were outstanding, I just have too much concern that you're not going to appear for me to reduce your bail to personal recognizance and just let you out. I also note that you'll be serving at least 9 days in custody at this point now because of the resolution of those other proceedings. So at this time, I think that that's an appropriate bail. If you remain in custody on these files for longer than 20 or 48 hours, you have the right to request a bail review. A bail review doesn't necessarily mean bail goes down. It means that bail can go up, it can go down, it can stay the same, but it means that a judge will review the bail that I just set to determine whether it remains appropriate. Understand the court's bail orders, sir.
Yes, Your Honor.
Do you have any questions? These matters are adjourned. Thank you. Have a good day.
I highly doubt this man lives alone. I'm sure there is someone there that can care for the animals. I very much doubt that this man has the mental or physical capacity to care for himself. I am sure that he is living with someone. So hopefully those animals are all okay. If not, I hope someone calls animal control quickly. No kidding. Well, they had to start court 20 minutes late because they couldn't get him to act like an adult and come to court. For real. That guy's, he annoyed me. He annoyed me so much. I'm so happy. Thank you. Almost a year. It's almost our anniversary, Bill.
Thank you, you too.
Just a heads up to everyone in the jail courtroom, Mr. Lockhart from the Public Defender's Office is in our physical courtroom, so don't be confused when there's no attorney standing up there next to you. He is appearing from our courtroom. You'll see him when he does speak.
Yes, I forgot. We have Bellingham Church Court.
All right, Mr. Lockhart, do you have any matters ready to go?
Looks like Mr. Forrest Miller is ready to go.
All right, Forrest Miller. We've got several cases. Morning, Mr. Miller.
Yeah.
Got 6A0271909, 6A0059319, CB0115536, 6A0110288, CB0115546, and 6A0372591. These are all set for arraignment. Probable cause has now been established on all of these. So with that, Mr. Lockhart, are you ready to proceed on the arraignments?
Yes, Your Honor. At this time, I would ask to waive a formal reading of rights and ask to enter not guilty pleas on each of these cases.
All right, thank you very much. Mr. Miller, at this time, I'm going to waive a formal reading of your rights and the probable cause. based on your attorney's request. I am entering not guilty pleas here today on your behalf as to all charges on all cause numbers. That does preserve your rights and defenses in regard to all of them. Mr. Good, does the city wish to be heard on conditions?
Thank you, Your Honor. The city's asking the bail be maintained in all these matters. Mr. Miller has 10 prior theft-related convictions. He also has 6 issued warrants currently, so I do think bail is appropriate in all these matters.
All right, thank you very much. Mr. Lockhart, would defense like to be heard?
Your Honor, we're just asking the court to take into consideration here just that Mr. Miller is not currently employed. There it is. He's currently homeless. He does have a case manager. Unfortunately, case management is out on vacation right now, so he has a little bit one less point of contact here. He is on EBT, and that he does know that he's got the other pending matters that are in warrant status out of other jurisdictions. But just that we're asking the court to take all of that into consideration if setting any amount of bail today.
Okay. All right. Well, Mr. Miller, while all of these are really, relatively low-level nonviolent offenses, your warrant history is really the court's concern here. It sounds like you're aware of the warrants, but you do have warrants out of Island County. Looks like those are post-conviction warrants. You got warrants out of Snohomish County. I'll hear from you in a second, sir, but I'm making a record. You have warrants out of Cascade, Snohomish County. That's 5 active warrants, actually 6 active warrants. So I am finding there's a risk of flight. Mr. Miller, what is it you'd like the court to know?
Island County, but mine's 10 years old, and I can't get rid of it.
Okay, yeah, those 2 warrants are older. The assault Forenberg 2 are from 2016. You also have a warrant from July of 2025 out of Snohomish County Superior Court, and then you have warrants from February, June, and July of 25 from Cascade Division, Snohomish County.
I've also served my time on that Island County map completely, dead, and they won't drop the warrant. It's 10 years old. I went back, I've done everything I'm supposed to do.
Okay, the 2 Island County ones, those are 10 years old. You are absolutely correct. They are post.
Clearly you missed something, right? Or you wouldn't be back in court for them. Something got missed.
Conviction.
And then my case manager was trying to help me get into treatment, and she said she can bring me to any new court dates. Didn't know when the new court dates were. And I'm getting my Sublocade shot, so there won't no more drug account.
Okay, so Mr. Miller, I hear all of that. Let's forget about Island County right now, okay? I'm going to pretend those don't exist. You have 4 active warrants out of Snohomish County, all on pending pretrial cases. You also have active warrants on all of these. Mr. Miller, I understand where you're coming from, but the court has to make a finding there's a risk of flight, sir. So I'll note your objection, but your warrant history and your lack of appearance speaks for itself. So I'm going to go ahead and make that finding. What I am going to go ahead and do is I'm mostly maintaining the bail, but one of the warrants, for whatever reason, went out significantly higher than the others. One of the controlled substance went out at 5,000 instead of everything else is 1,000. I'm just going to across the board set it at 1,000 bondable, which I think is all perfectly appropriate at this point. So all in all, sir, I'll add this up here in just a minute.
Over $20, I won't bail out. So it's yeah.
Okay, I understand it's frustrating, Mr. Miller, but I just need to be clear.
No, it's
All
frustrating
the court is
is
basing this off of is your appearance history.
Mr. Miller, you got to talk into the microphone. We're not able to hear you.
What's frustrating was I was about to go to treatment. What's frustrating is I was about to get a Sublocade shot. What's frustrating is I would have been not doing this shit anymore. What's frustrating is all that's about to go away. But
All right.
I'm sure what's also frustrating is that you have 0 impulse control. None. No self-control whatsoever. And it shows.
I gotta get a new judge.
So, Mr. Miller, the conditions otherwise, Mr. Good, I assume you're asking for pretrial supervision, you said, on the controlled substances, or no?
Yes, Your Honor. I
Okay.
did not ask, but yes, that is something I seem to be asking for.
All right, we've got 3 controlled substance violations pending in this court. There are others pending in other jurisdictions. I am finding there is clearly a nexus between substance use and these allegations. Pretrial supervision is the least restrictive alternative here, as well as the bondable bail to ensure that Mr. Miller follows conditions of the court. So, Mr. Miller, if you were to post bail or bond, you need to report to the Whatcom County District Court Probation Office. Mr. Miller, you probably don't want to flip off the court. Not a good idea, sir. So, if you want to take a seat, you can take a seat, but you need to stop with this behavior. All right, Mr. Miller, you need to report to probation upon your release from custody if you post the bail or bond. The conditions here. Mr. Miller, you just want to stop talking at this point. Just stop talking. Mr. Miller, if you don't stop talking, I'm simply going to have you removed from the courtroom. So sit down, be quiet, and listen. If you need a moment to compose yourself, that's okay. But here's what we're going to do. If you post a bail or bond, you need to report to the District Court Probation Department. All right, deputies, we're done. Can you please just remove Mr. Miller from the courtroom? He's interfering with court proceedings. I'm ordering all the standard conditions with pretrial supervision. I'm going to set them to Monday, August 24th at 8:30 for pretrial. Madam Clerk, what's a good out of custody? September 22nd, 1:30 will be the out of custody date. And I am finding Mr. Miller eligible for the public defender on all of these. I think we maybe already did, but we've already sent them. Okay, so he's going to get an attorney on board here. All right, and Mr. Lockhart, if you can just note refusal on the defendant line, that'd be fine.
Certainly, Your Honor.
And I will add, actually, to the document just that Mr. Miller was removed from the courtroom due to his outbursts. Let me just add that real quick. There we go. All right, it is ready for signatures. Who else is ready, Mr. Lockhart?
The next one is Simone Bailey Cobb.
All right. Simone Bailey Cobb, cause number 6A0374086, and this is on for an arraignment and a return bench warrant. Morning, ma'am.
How are you?
I'm okay. How are you doing today, ma'am?
Oh, I'm good.
Good. Okay. All right. Well, we are just here on the Bellingham matter. I believe you may have another hold, but this is just on the one charge, driving suspended second. Mr. Lockhart, PC, of course, was established when the warrant went out. Are you ready to go on that arraignment?
Yes, Your Honor. At this time, we had asked to waive a formal reading of rights and asked to enter a not guilty plea on our behalf.
Okay. At this time, ma'am, I'll waive the formal reading based on counsel's request. I will enter a not guilty plea on your behalf, which does preserve your rights and defenses to this charge. Mr. Good, on conditions?
Thank you, Your Honor. City's asking you to maintain bail based on Miss Bailey Cobb's 30 prior warrants and 2 issued bench warrants. She has no prior driving spin license seconds, 3 prior driving spin license thirds, 3 prior DUIs.
3 prior DUIs. Okay.
Oh, can I say?
You certainly can, but let me hear from your attorney first, and then I'll hear from you, ma'am.
Okay.
Mr. Lockhart?
And Your Honor, Ms. Bailey Cobb indicated to co-counsel just that she does not have an current ability to post any amount of bail at this time, Your Honor. So we're just asking the court to take that into consideration. It sounds like that she had kind of been working with the getting the interlock in Department of Licensing, and it sounds like the most recent suspension was due to an FTA, but that she has been kind of working with them in general. So she is trying to make the right steps forward, but at the same time, Your Honor, she just isn't able to move forward. It's not very easy to get through a lot of those processes, especially with the history that she has. So we're just asking the court to take that into consideration, as well as her inability to post any amount of bail.
Thank you. Ms. Bailey Cobb, what was it you wanted me to know?
I just wanted to ask if I worked to get PR'd with it, and I did have the bongo, everything on my car, but they put in my car and I couldn't get it back, and then they suspended my license when I went to treatment. I know that they suspended it, and now I have to suspend the second, and I couldn't. I had everything in line, and I've been having the bongo and stuff on my car. I just when everything got chicken like that, I couldn't pay for everything to get back.
Sure.
Right? Suspended. They told me that I went to treatment. They didn't tell me that. And my police officer, they suspended my license for missing court when he was going to treatment that day. And I missed court, and they suspended it anyways.
Okay. All right. Well, Ms. Bailey Cobb, a couple of things the court needs to consider. just to be totally clear, you do have a couple of no bail holds out of Superior Court, so you're going to need to address those regardless. The only couple of things I'm considering are really these two things. One, I do have to consider your warrant history. I do see the 2 active warrants out of, looks like, is that Cascade, so down in Snohomish, and then, what's EGD? Oh, Evergreen, down in Snohomish. And those are both on, it looks like, post-conviction DUIs, so I'll be frank,
The same DUI.
that does cause the court some concern, ma'am.
I've already done the time. She's making me redo the time.
I
She told me to
understand. So here's where I'm at, ma'am. The bail it's $1,000 bondable. Given your driving history, I think that's probably pretty reasonable. I'm okay with a $100 cash alternative, but I'm going to have to make the finding that there is some risk of flight. Not only do you have those 2 active warrants, but your overall warrant history is pretty significant. So it's going to be a $1,000 bond, $100 cash alternative to assure your appearance in court. Court will make that finding. Other conditions, Ms. Bailey Cobb, pretty standard. Just show up to court on time. Don't pick up any new charges while these matters are pending. And, of course, don't drive without a valid license and proof of insurance. So that'll be the order in this court. You'll still have to see a Superior Court judge in Superior Court, and they can address the bail there. Do you have any questions about any of those conditions, Ms. Bailey Cobb?
No.
Okay. I'm going to find you eligible for an attorney at this time, ma'am. We'll get you someone assigned. You're always free to hire your own attorney if you wish to, but certainly not required to. And I'm going to find you a couple of new court dates here in just a moment.
Thank you.
You're very welcome. All right. Not quite done, ma'am. We're almost done. Let me just get you a new court date here. So, in custody court date, we're going to go to Monday, the 24th of August, 8:30. Out of custody court date, we're going to go to September 22nd at 1:30. Once you have an attorney on board, if you reach a resolution prior to then, it can be noted up sooner than that, but that'll be the standard date at this time. Do you have any questions about that, ma'am?
No, thank you.
All right, one final thing before we let you get on your way. Are you okay if I have defense counsel sign the document on your behalf today?
I'm here to ask you, right? Yeah.
Sorry, what was that?
I said, I guess you asked me, but yeah, go ahead.
Okay, yeah, we just have our attorney in the courtroom here, and probably easier for them to just sign for you if you're okay with that. Okay, I'm going to go ahead and get out of the document. That is ready to go, Mr. Lockhart, and I think that takes care of everything. So, Ms. Bailey Cobb, thank you very much, ma'am.
Thank you.
All right, you're appearing through Zoom and Polycom, and your attorney, Mr. Knopfsinger, happened to be here for attorney pre-trials, and I would have contacted the chief public defender, but since Mr. Knopfsinger was here, we asked if he could help, and fortunately he was able to do that. So you were charged with looked like a felony a long time ago, and I think this matter was resolved in August of a year ago. You were put on probation.
You offered me probation or 7 days. Yes, sir.
Well, you got probation with 18 days jail, credit 18, and you were placed on probation for 12 months. You had to do anger management and abstain from alcohol, no contact with Kayla Coffee.
There's been no made sure there's no contact with her. I moved.
Yeah. All right, and then in October, you had pled guilty to a probation violation, and you did 15 days again. Then we had a probation violation arraignment set for January 12th, and you missed it.
Oh, so I'm sorry, I didn't know, sir.
Well, tell me what your address is.
My address is
Okay, I'm sorry. Tell me that again.
It's where all my milk. Yeah, it's where all my milk can go.
Okay, Delaware Street, and then where?
I said Delaware Street, Mishawaka, Indiana. This is my
Mishawaka.
mailing.
Okay. And what is your correct, is your number the same as it was, the 724?
No, I've changed my number since then, sir.
And what is that now?
269.
So we roped Mr. Nossinger into this inappropriately. He wouldn't have been on the hook because his representation actually ended when you were sentenced. So I'm still appreciative of it, but if I'd taken a peek at it, I wouldn't have bothered him.
I'm trying to read lines here to Judge. It looks like there was a domestic violence that was authorized in November of last year. I wonder if the allegations of violation of probation are related to that new domestic.
Well, let me find that. Let's see.
I thought you told me you canceled all the new charges that were trying to come. That's what I thought. That's why I thought I didn't have to come back other than for probation.
Well, let's see if we can figure it out.
I just want to get over with, sir. I'm trying to get back to job. My real goal here is to get to a job corps. I'm just trying to
Okay,
finish my
hold up a minute. I'm trying to figure out.
I'm sorry.
Where is?
I just can't understand how wanting to get a job or wanting to get into the job corps or wanting to go to rehab or wanting to start an abuse or wanting to do this or that or the third, whatever. Why is that only a consideration when you're in custody and it's not something worked on out of custody? It is not until you're under the order of the state to do such things that you do such things. I don't understand it.
No show bench warrant after 48 hours. All right, here's the petition. It says petitioner states defendant was placed on probation August 19, 2025 for an original period of 12 months based on a conviction for domestic violence and has violated the conditions of probation by failing to abstain from the use of alcohol and drugs or to test on demand. Defendant failed to test as required on November 26, December 2nd, and December 12th. So apparently you were still on probation, and then I guess you disappeared after that. Let me see what you never started your classes, it says, and the recommendation was revoke. And it doesn't say, the suggestion back then was to revoke and give you jail, but it didn't put on here how many days they were recommending. Okay, and it said he had maybe that got dismissed, but it said it said he had a warrant out for him.
I am looking at one right now. It does look like.
I remember that being dismissed, sir.
Hold on. What, Mr. Nossinger?
Yeah, it does look like there was an open DB case. It's a 25 case. Oh, because it was authorized on November 17 of last year. It does look like he has a no bond on that case too.
Oh, so he's got another case that he's got, and okay.
Yeah.
All right, so he should probably just plead not guilty to this, and I'll change his bond, but he's got that one hanging out there, so.
Yeah, it doesn't look like he's arraigned on that either.
He's gonna see the magistrate then later today.
Okay, very good.
All right, so we'll show that you're pleading not guilty. So apparently you're gonna see the magistrate on your other case. And I'll talk to Mr. Stickley. I'll let him know this is out there. I'm sure he's going to approve Mr. Knopfsinger being reappointed in this case, but that's really Mr. Stickley's decision, not mine.
Yes, sir.
It makes sense, Judge.
I'm gonna change this to $1,000 cash or surety. I'm sure you're gonna be dealing with something more on the other one. Set age. And I just, if you didn't have anything else, I'd probably leave a higher bond, but I think you're gonna get a higher bond in that other case. So, all right, you're all set for today. Thank you.
So I'm a little confused on what's happening.
You're going to see, I believe Mr. Knopfsinger will be appointed for you in this case. Your bond will be 1,000 cash or surety. You're going to see the magistrate on a case you were charged with 6-8 months ago, but have never been arrested until now on. So you've got an open domestic violence charge hanging out there.
I've been arrested for it though, sir.
All right, well, you can deal with that.
Yeah, you've been arrested for it. Yeah, that's quite right, sir. You're in custody now. $1,000 bond. Yeah. You've been arrested for it. Sure thing. Have a good day. Oh, you guys, I told you I had fun stuff. I'm sure that the public defenders already have that list. Yep. They go when they get sent back in the breakout room. They go into the breakout room fully prepared with that list. Hey man, I try to find you guys the best. And pregnant and on their period. Yep. That was my favorite. I think that was my favorite. I'm pregnant, and then what? 2 minutes later, I don't have a pad and I'm on my period. You can't search me. Well, that one guy tonight, he lack of oxygen. Yeah. And he had to go into the ER because he had food around his heart. I know it was fluid, but you listen to that. You listen. He said food around his heart. That's all he was thinking about. I'm not trying to be mean, the guy. He was a douche. Oh yeah, the pantless bandit. Morty, you weren't here for him. Hold on, Morty. You guys want to watch the pantless bandit again? I think Morty missed that one. No, you were here. You were here. Who was Bill? Bill wasn't here. Bill wasn't here. Wait, I gotta show the pantless bandit.
So this is going to be an experiment. Ms. Rawls, usually when we have someone in custody that needs an interpreter, we bring everybody in here into the court. Are you at your office back on Washington?
Yes.
Okay. All right. So we'll see what we can do with language line and trying to get everybody heard from a different, like Zoom and from in person. So we'll just see how it goes. If you can't do it, then you're going to have to come in so that we can get that done.
That's fine, Your
Okay.
Honor.
Okay. All right, this is Magistrate Milmore, sir. Are you Rodney? Oops, that's not what I'm looking at. Rodney Armstrong?
Yes, ma'am.
Okay, and I would prefer that you don't hang out on the wall, that you stand on the tables, at the table, sir, so I can see you better. Thank you. All right, and your appearance, please, Ms. Rawls.
Thank you, Your Honor. Assistant Public Defender Linda Rawls, appearing on behalf of Rodney Armstrong for his arraignment.
Thank you. So your middle name is Dale, is that right?
Yeah.
Okay. All right, so I have to be able to see you and not the back of your head, sir, so. Okay, so this is file number 26-02157OM. This is a complaint in the people of the city of Lansing versus Rodney Dale Armstrong. Sir, it is alleged on or about August 5th of 2026 at 428 South Washington Square, city of, is he sitting on the table?
Yeah.
It's supposed to be
Sir, you gotta be
standing up.
standing up.
I'm sorry, man. I'm sorry. Damn, I'm sorry.
Okay. Okay. At 428 South Washington Square, city of Lansing, Ingham County, Michigan. Sir, the charge alleges that you did knowingly furnish a Lansing police officer with false information, to wit, an incorrect name, at that location in Lansing during the officer's investigation of a violation of state or local law or ordinance. So that's contrary to law, Mr. Armstrong. It is a maximum penalty on the misdemeanor, 90 days in jail and or a $500 fine. So do you understand the charge and the maximum penalty?
At the time, I didn't understand the way it was said. When it was said to me, then I was up under, I had just came from a bunch of.
No. We don't want to talk about what happened.
Yes,
Yeah,
yes,
but you
ma'am.
wanna-
Yes,
you
ma'am.
wanna
Yes,
talk
ma'am.
about
Yes, ma'am.
with your attorney.
Yes, ma'am.
Okay.
Yes, ma'am.
All right. So you have rights, Mr. Armstrong. We're gonna go over those. You have the right to plead guilty, not guilty, or stand mute. You have the right. Let me just get through this. Do you know your rights? Because I want to make sure.
Somewhat, a little bit, ma'am, a little bit.
Okay, well, let's just go through them because they're really important, and I'm sure Ms. Rawls would agree with me. So just bear with me so we can get through this. All right, you are presumed innocent. Okay, if you're found guilty, it has to be beyond a reasonable doubt. So you have the right.
I get it, ma'am. I get that. Yeah.
Good. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, Mr. Armstrong, the court can order them to appear. You also have the right to a lawyer, and if you can't afford one, we're going to get one for you at that court cost. Do you understand those rights?
Yes, ma'am.
Is there? Good. Okay, and is he applying for an attorney, Ms. Rawls?
Yes, he is, Your Honor.
All right, very good. I think that's a good decision. So we're going to enter a not guilty plea for you, Mr. Armstrong, so you can come back. You'll talk with your attorney about how to handle this and prepare a defense. And that hearing is coming up. That's Monday, October 5th. That's at 9:30 a.m. with Judge Buchanan. So you should have the notice to appear and a yellowish color notice for your instructions. You got it. Perfect. That's exactly what we need to make sure you got. Okay, thank you. Bear with me. I just got one thing that I need to look up here, sir, and then I'll be right back with you. Okay, so I'm looking at you've been in this court a few times, And my goal here is to make sure that you keep coming to court. You do have, let's see. Yep, one more. Okay, so I am going to grant you a PR bond on this. It's not a violent charge, okay? And you know that you've got your next appearance date, October 5th, so you don't want to miss that. You've got your paperwork. So I am going to set a $100 PR bond, Mr. Armstrong. So I'm going to tell you, don't miss any court dates. Don't violate any state or local laws while you're on bond. Don't leave the state without permission, and got to make sure that you follow all these conditions to remain out on bond. Do you understand that, Mr. Armstrong?
Yes, ma'am. Yes, ma'am.
All right. Anything else for the record, Ms. Rawls?
No, Your Honor.
All right, then you're all set, sir. That concludes your arraignment.
Yeah. Yeah.
That will never get old. I was not expecting that when I was editing it. Oh, it would have been good, you know, if it was just him having his, oh, I'm sorry, ma'am, I'm sorry, oh, damn. Oh, sit on the table, ma'am. I mean, that would have been good just having that. Or the farting up against the wall. But no. The one-legged paper pants bandit arrived. It was just priceless. I had to. Oh, golly. Oh, you guys are great. Oh, you made me laughing so hard. I'm such a mess now. Oh, well. I'm going to be going to bed. I wonder what he did to have to be assigned a full-on paper suit. Like, normally people come in their street clothes to that court. Normally. So, if he's not coming in his street clothes, I have a feeling there's an officer having some inmates clean the back of a cruiser right now. Cause, yeah. They don't assign paper suits for nothing. That's my guess. They don't give jumpsuits in that court. You go in for arraignment. You don't get a jumpsuit unless you are held without bond or detained longer than a 1-day excursion away from home. They don't give you a jumpsuit. You go in your street clothes. You attend arraignment in your street clothes. You're welcome, Jen Callum. I'm gonna go good night too. Ooh, possibly. I didn't hear a whole lot of what happened. Man, I want that body cam footage now though. guys. Quit it! Quit it! He redefined the officers needing backup. All right, you guys. Oh my God, I can't anymore. I just can't. Oh, I love you guys. You guys are so great. Thank you so much. Don't forget about Jerry streaming Spider-Man tomorrow at 3 in Discord. And I've already got a few court ideas on the horizon. I saw a couple of things today that just might pan out to be a good show. So, thank you guys so much for being here. I love you all. Be safe, be well, sleep sweet, and much love.